A confidential letter, which was exposed by the Danish newspaper BT, reveals that political influence might be skewing the decisions of the International Criminal Tribunal of the former Yugoslavia in The Hague, the ICTY. After the atrocities of the Second World War, the concept of international law has been promoted in the United Nations in order to prevent a recurrence of such crimes against humanity. But the various treaties and conventions approved to protect the rights of all human beings wherever they may be have depended on each government to uphold and respect. The measures available for the international community to enforce the respect of human rights remained weak and few. The International Criminal Tribunal for the former Yugoslavia, the ICTY, was established by Resolution 827 of the UN Security Council before the war in Yugoslavia ended. The Security Council extended the court's existence and called it to end its work by the end of the year 2014. The establishment of the International Criminal Court, the ICC, in The Hague in 2002 was based on the Rome Statute, the treaty from 1998, which has so far been adopted by 122 states around the world. The court was designed to establish the means to enforce the existing UN resolutions against genocide, against crimes against humanity, and against war crimes. Individuals could be extradited to the ICC to stand trial in such cases where their own states failed to try them for their crimes. If the crimes were committed within the territory of a state which signed the Rome Statute, the court's jurisdiction would apply, and the court could try and sentence the suspects. The International Court of Justice, the ICJ, is a courthouse established in 1946 to settle disputes between states and to give advisory opinions on the application of international law. For example, the ICJ gave its advisory opinion that the wall of separation built on the occupied West Bank by Israel is in violation of international law.
Actually, it was the United States, along with the British, who were strong advocates for the idea of a world court originally around the turn of the 20th century. And that said, there's always been a little bit of a love-hate relationship in the sense that within the U.S. there have been a range of views about the idea of a world court. Was it a good thing? Would it help bring about peace? Or would it be a body that infringed on U.S. sovereignty? And that those themes have persisted since the beginning, I think.
Indeed, the idea that crimes committed in foreign states could be tried by international courts such as the ICTY, the ICC, or the ICJ is especially threatening to countries which regularly send their forces across the border on violent missions, most notably the US and Israel. It is no coincidence that the US and Israel exerted tremendous pressure on the Palestinian government not to sign the Rome Statute, even after Palestine was recognized as a state by the UN General Assembly. If the Palestinians signed the statute, every Israeli soldier stationed in the occupied Palestinian territory would be at risk of extradition to the ICC. The ICC was criticized that it had so far only tried suspects from Africa. The court argued that it has been invited by African countries to assist in applying international law in Africa, but it remains a blatant fact that the court did not try international law offenders from Western states.
Yes, it is true that Africans and a few token Serbs thrown in. The big fish, the United States and the NATO nations, are free to violate international law, to violate human rights with complete impunity. Since the ICC was founded, the United States invaded Iraq. You could call that a genocide. To this day, there are children in the city of Fallujah being born with grotesque deformities as a result of some of the weapons being used there, depleted uranium and so on. Israel attacked Gaza, targeted a civilian population, practiced collective punishment of a civilian population in violation of all the norms of international law and the Geneva Conventions. And the outgoing prosecutor, Mr. Moreno Ocampo, said that Palestine had no standing in the ICC. So it seems as though these rules apply only to weak nations.
The ICTY, the Tribunal for